For any help regarding constitutional law homework help, visit https://www.lawhomeworkhelp.com. Email info@lawhomeworkhelp.com or call us at +1 678 648 4277. The law has parts. A. It has T tables 3 parts, and concerns for civil inter his ogati and new on C. Overseas Prison Agency Centers. The statute states the 2O agency should balance versi all overseas prisons waterboarding, may be used on specifically states LTIB ha ERTT and ha IES, and said national security. However, the statute B. The head of the new agency shall be appointed foreign combatants interrogation technique suspected of terrorism. ES, such as TED by the Secretary of Defense and confirmed by the Senate. The Secretary of Defense may only consider C. Retired military officers for this appointment. C. The head of the Overseas Prison Agency may either the Secretary of Defense or the Chief Justice of the Supreme C be removed for cause ort. By. In early 2014, reports emerged that Interoga President Obama ordered the imprisonment, and they were Tian of Tiaroga U.S. citizens that were caught committing terrorist actions. Su prison agency objected to ENHA. Privately, senior TED and secret officials acknowledge that these 3 PR prison in Poland that is overseen by the overseas and said interrogation techniques, including waterboa Eisener writing. SWER. Lawhomeworkhelp.com. The families exceeded his L of EGA the LATHUT, are Horit EEPRY in ordering Eiseners bring their family members suit. They allege that T imprisonment, and he president has interroga GHT Tian. Moreover, T lawsuit, they demand access to all documents related to the interrogation of the overseas are unconstitutional they argue, and that S all TH, Hudar BEPR STR OUK divisions own of TH. As part E over of TC's Air Prison 3 USC, and his advisors ITIS NS. The requested documents agency President E. President Obama responds that, as well as emails between include communications between the all of these documents are protected officials of the overseas by prison executive privilege. Imagine that you are a member of the United States Supreme C by per YSOUA's URC EVA 7 all AGU page ESS to EOPI on of TH ORT. You are asked on the last page of your essay, please address the implications of your decision for SSA. Please address the implications of your decision for SWRI, DITTHSPNI AST, in WEC Hitch, ORT IUNTH addresses case. PEA lo CH of TASEW his issues. RITA won the president's ability to prosecute the war on terror. Lawhomeworkhelp.com. Analysis of the Overseas Prison Oversight Law. The challenge to the Overseas Prison Oversight Law, OPO, raises several constitutional issues regarding the separation of powers doctrine, presidential power, and executive privilege. This opinion reviews and analyzes the constitutionality of A. the president's actions to imprison and interrogate 3 U.S. citizens, B. the president's assertion of executive privilege in response to the prisoner's family's request for the production of documents, and C. all 3 parts of the OPO. Ignoring any claims of due process violations, the imprisonment and interrogation of the 3 U.S. citizens is constitutional. President Obama's assertion of executive privilege over the requested documents is valid, except for those not related directly to national security or diplomatic affairs. Part A of the OPO withstands constitutional scrutiny in terms of the separation of powers doctrine, while Parts B and C are unconstitutional as violations of presidential power. I. Imprisonment of U.S. citizens. In our prior ruling in Hamdi v. Rumsfeld 1, this court recognized the power of the federal government, but ignoring any aspects of due process violations, to detain U.S. citizens in support of forces hostile to the United States as enemy combatants so long as such detainees continue to pose a threat to U.S. forces. As the detainees in this action were caught committing terrorist actions, and could reasonably return to committing terrorist action upon release, their detention fits the requirements outlined in HAMD. However, it is important to note that this detainment is not unconditional. As U.S. citizens, the detainees have the right to challenge their enemy. LawHomeworkHelp.com. Combatant status. Moreover, the government can't hold the detainees for the purpose of interrogation and must demonstrate a reasonable potential for harm upon their release. However, given the limited facts on the case and our dismissal of any due process challenges for the time being, the detainment of U.S. citizens withstands constitutional scrutiny. On the issue of the detainees' families standing to bring this action, a minor, yet potentially disputable issue, HAMD also provides the standing for the families of the detainees to sue, as the proper next friend of the detainees. This provides clear standing in this case. 2. Executive privilege. President Obama's assertion of executive privilege is largely valid, due to the nature of the interrogation documents and the exempted documents outlined in United States v. Nixon II. In Nixon, this court asserted the necessity of due process and the ability to collect evidence as overcoming the president's generalized interest in confidentiality, but protecting those documents from disclosure whose contents relate to military or diplomatic affairs where confidentiality is essential. In the instant case, as most of the documents requested concern interrogation of terrorists, the information related to the interrogations has a clear relationship with national security and military affairs. Thus, President Obama's assertion of executive privilege will largely stand based on the interest in national security. LawHomeworkHelp.com. 3. Constitutionality of the OPO. Part A of the OPO. Part A of the OPO withstands constitutional scrutiny in the context of the separation of powers doctrine based on the precedent set in Mistretta v. United States 3. This court ruled in Mistretta that while Congress cannot generally delegate its powers, it may do so with an intelligible principle to which the body or person with the delegated power must conform to, based on a previous ruling in J. W. Hampton Jr. and Company v. United States 4. The test developed in Mistretta requires Congress to provide broad directives while still enumerating specific and detailed requirements, i.e., the public agency which to apply it, and the boundaries of this delegated authority. In this case, the broad directive part of the test is met through the requirement of the OPO to balance concerns for civil liberties and national security. This high-level and general goal matches the acceptable set of goals outlined in Mistretta regarding fairness in sentencing. Moreover, by specifying the permissibility of enhanced interrogation usage by the Overseas Prison Agency, OPA, the OPO fulfills the condition of specific and detailed requirements required by Mistretta for a delegation of power to survive constitutional scrutiny. LawHomeworkHelp.com. Given that the OPO is permissible under the separation of powers doctrine, the basis for Part A, withstanding all constitutional scrutiny, then turns to the legal permissibility of enhanced interrogation techniques such as waterboarding. If enhanced interrogation techniques are not permissible, then that aspect of the OPO must be struck down, leaving it without any specific and detailed requirements provided by Congress for the OPA. However, this court has not ruled on the legality of enhanced interrogation techniques, and will not do so at this time as that is not the issue on hand. Part B of the OPO. Part B of the OPO is partially unconstitutional, with the appointment process outlined as a violation of the Appointment Clause of Article 2, Section 2, using the determination of an officer of the United States established by the ruling in Buckley v. Valeo. The President has the exclusive power to appoint officers of the United States, with the advice and consent of the Senate, as provided by the Appointment Clause of Article 2. Moreover, Congress may choose to give the power to appoint inferior officers to the President alone, the courts, or the heads of departments. Buckley established the standard for an officer of the United States as an official who exercises significant authority pursuant to the laws of the untied states. However, the head of the OPA does not fit this qualification, as similar positions, such as the head, known as Director, of the Federal Bureau